So
I think it's recording already.
mhm.
So hello everyone and welcome to another ITSS podcast. I'm Vittoria Brunazzo, member of the human rights team of ITSS, and today I'm here with Dr. Sergii Masol. Thank you for being with us.
Thank you for the invitation.
A short introduction. Dr. Sergii Masol is Humboldt postdoctoral research fellow at the University of Cologne. Sergii obtained his doctorate in law from the European University Institute in Florence, where he was also a research assistant. So thank you again, and let's start with the question. So I will start with a pretty academic one to provide us just some context. Can you talk to us a little bit about the international criminal justice and how is it tied with the human rights discipline?
Thank you very much for your question. Historically, international law has been dominated by state-centric approaches. So international law still governs primarily the rights and obligations of states. So by way of comparison, criminal law addresses the conduct of individuals, and breaches of criminal law are subject to a penal sanction by a state. International criminal law is a relatively new hybrid body of international law. The sources of international criminal law are those of international law, but the consequences are of the penal nature. ICL, that's international criminal law, prohibits certain conduct, some of the most serious offenses known to the humankind, and imposes criminal responsibility for such offenses directly on individuals. Violations of international criminal law are punished through international judicial mechanisms. The overwhelming majority of such mechanisms have been ad hoc, that is designed and established to deal with specific conflicts. For example, the International Criminal Tribunal for Rwanda, which was created by a resolution of the UN Security Council, tried individuals responsible for the Rwandan genocide and other international crimes committed in 1994. The only permanent institution is the International Criminal Court, which was established in accordance with the Rome Statute of the International Criminal Court. This treaty was signed in 1998 and came into force 4 years later. The subject matter jurisdiction of the International Criminal Court covers 4 categories of crimes, namely genocide, war crimes, crimes against humanity, and the crime of aggression. Now, what about human rights? The term human rights can be used in 2 senses. On the one hand, it refers to human rights in a strict sense, that is, the entitlements that every person, you and me, has simply because he or she is a human being, and these entitlements are typically opposable to a state. States must respect, protect, and fulfill human rights. For example, the right to freedom of expression that I'm exercising right now, or the right to food that I'm going to exercise today at lunchtime. On the other hand, human rights in a broad sense, or lato, to use the Latin expression, encompass not only human rights proper, but also norms of international criminal law and international humanitarian law, that is, the law that regulates the conduct of war. They aim to protect the humanistic values of the international community. In academia, a framework that spans these bodies of international law is sometimes called humanities law. In UN documents, as well as in academia, the concepts of a human rights violation and an international crime have at times been used without any substantive delineation. However, international human rights law, international humanitarian law, international criminal law, are separate bodies of international law, and their interactions with one another is a fascinating topic for research. In fact, the relationship between human rights law and international criminal law was the topic of my PhD thesis. The Rome Statute of the International Criminal Court explicitly regulates the place of international human rights law within the framework of applicable law. Article 21, paragraph 3 of the Rome Statute stipulates that application and interpretation of law must be consistent with internationally recognized human rights and be without adverse distinction founded on certain grounds, such as religion, ethnic origin, age, color, etc. It follows from this that norms of international human rights law can influence both procedural and substantive facets of international criminal law. As regards the procedural dimension, the ICC, the International Criminal Court, must comply with internationally recognized human rights at all stages of the proceedings, and some of the relevant human rights norms include the right to a fair trial or the right to liberty. As regards the substantive dimension, the essence of international crimes has been argued to consist in serious and mass violations of human rights. Almost every international crime would be a breach of international human rights law. But the converse is not necessarily the case. So first, international criminal law and international human rights law are structurally different. The latter, the human rights law, establishes the lists of human rights and contains obligations of states towards individuals. In cases of abuse, the accountability of states results in civil redress for losses inflicted on victims. By contrast, international criminal law establishes catalogs of offenses and is principally directed at the criminal responsibility of individual perpetrators of these offenses, thereby making the involvement of the state secondary, so to say. And then in international criminal law, the intent of an alleged perpetrator has to be proven. And when it comes to the crime of genocide, for example, the mere attempt to commit it is punishable. By contrast, the identity of the individual perpetrator is less important or even irrelevant in international human rights law, where the focus is on the state of mind of a victim and on the harms inflicted on victim. This entails a broad interpretation of human rights law norms in light of the principle of effectiveness, which in turn leads to stronger human rights protection over time, as opposed to the principle of legality in international criminal law. So what does it require? The principle of legality. The definition of a crime shall be strictly construed, and in case of any ambiguity, this definition shall be interpreted in favor of the person being investigated, prosecuted, or convicted.
Okay, thank you so much. And now turning to the events in Ukraine, how does the International Criminal Court is intervening right now on the ongoing conflict in Ukraine? Do authorities feel like responsible authorities responsible from severe violations of human rights could ever be brought to the court and have a trial, or is it complicated to how the conflict is going on right now?
Well, as I said, the International Criminal Court, I will use the acronym ICC to make it easier, has jurisdiction over 4 categories of crimes. And to answer your question, it is necessary to separate the crime of aggression from the rest of statutory crimes owing to the special legal framework pertaining to aggression. So the ICC cannot exercise its jurisdiction over the crime of aggression when committed by nationals of a state that is not a party to the Rome Statute, unless the situation is referred to the ICC prosecutor by the UN Security Council. Ukraine is not a state party to the Rome Statute, nor is Russia, nor is Belarus, by the way. Moreover, Russia has a veto power in the UN Security Council. And since the beginning of Russia's full-scale invasion of Ukraine, the Ukrainian government has explored the possibility of establishing an accountability mechanism to allow the prosecution of this horrendous crime. And there are a few options on the table. First, domestic prosecutions in Ukraine under Article 437 of the Ukrainian Criminal Code, which prohibits the crime of aggression. As a matter of fact, Ukraine has already initiated domestic criminal proceedings. However, the existing domestic option or a hypothetical internationalized hybrid domestic option suggested by some commentators has deficiencies, notably the legitimacy deficit, possible accusations of victor's justice, and of course the problem of immunities of the head of state, the head of the government, and the Minister of Foreign Affairs. Alternatively, there can be an interstate agreement on the establishment of a special tribunal. Ukraine's preferred option seems to be an international tribunal on the crime of aggression established by an agreement between Ukraine and the United Nations with an approval by the UN General Assembly. However, such initiative apparently lacks political support from the international community of states, at least for the time being. And needless to say that none of the outlined options play down the importance of amending the relevant provisions of the Rome Statute on the crime of aggression. Meanwhile, this July, in the beginning of July, the International Center for the Prosecution of the Crime of Aggression against Ukraine began to work in The Hague. It is hosted by the European Union Agency for Criminal Justice Cooperation, known as the Eurojust. In its investigation of the crime of aggression, this newly established entity aims to contribute to the analysis of evidence, enhance ongoing and future investigations, and facilitate case building for future trials. The center is composed of selected national prosecutors that are already participating in the joint investigation team to which the center is linked in its operations. And Eurojust provides various kinds of support, including operational, financial, logistical, legal, including the support for preserving and analyzing evidence. When it comes to alleged war crimes, crimes against humanity, and genocide, the ICC is actually engaged with the situation in Ukraine very actively. How is this legally possible if neither Ukraine nor Russia is a state party to the Rome Statute? In 2014 and 2015, in accordance with Article 12, paragraph 3 of the Rome Statute, Ukraine accepted this court's jurisdiction over alleged statutory crimes occurring on its territory, except for the crime of aggression. The first declaration of Ukraine concerned alleged crimes committed from late November 2013 until late February 2014. That is the period of the Euromaidan protests. The second declaration was about the ensuing Russo-Ukrainian war from late February 2014 onwards, that is with an open-ended date. Nevertheless, the situation of Ukraine remained at the preliminary examination stage for several years. Only, if I'm not mistaken, on the 28th of February 2022, that is just a few days after Russia's full-scale invasion of Ukraine, the ICC prosecutor, Karim Khan, announced he would seek authorization to open an investigation into the situation in Ukraine. On the 1st of March 2022, he received a state party referral from Lithuania. A large group of other states followed the example of Lithuania almost immediately. And next day, on the 2nd of March 2022, the ICC prosecutor eventually opened an investigation. Technically, one referral from Lithuania would have been enough, but the fact that a few dozen states did the same clearly sent a strong political message to victims of atrocities, to the Kremlin, to the Ukrainian government, and to the international community as a whole. In March 2023, if I'm not mistaken, on the 17th of March 2023, Pretrial Chamber 2 of the International Criminal Court issued arrest warrants for Vladimir Putin, the president of Russia, and Maria Lvova-Belova, the president's commissioner for children's rights in Russia. And the chamber considered that there are reasonable grounds to believe that each of the two suspects bears responsibility for the war crime of unlawful deportation of population and of unlawful transfer of population from the occupied areas of Ukraine to Russia, which was contrary to Article 8 of the Rome Statute. Currently, many Ukrainians have high hopes of the International Criminal Court, yet it must be borne in mind that the ICC was not designed to try thousands of individuals, nor does it have sufficient financial and human resources. We should expect a few trials in The Hague at best, whereas the rest of issues would have to be dealt with at the domestic level. If I'm not mistaken, 24 countries have started their own investigations of international crimes allegedly committed during the Russo-Ukrainian war. And no doubt, the main burden is placed on the shoulders of Ukrainian investigators, Ukrainian prosecutors, and Ukrainian judges. More than 98,000 instances of alleged war crimes, crimes of aggression, and other war-related crimes have been registered at the General Prosecutor's Office of Ukraine. On the one hand, 98,000 is a gigantic number, which is likely to increase because the war continues. On the other hand, less than 10% of all prosecutions in Ukraine concern Russian prisoners of war. The rest of national criminal trials are in absentia, and convicts do not actually end up in jail. By way of comparison, trials in absentia are not possible at the International Criminal Court. This court would be able to try individuals from Russia only if they are arrested in Ukraine or in a state party to the Rome Statute, and then surrendered to The Hague. Because, as you can imagine, it is highly unlikely that the Kremlin would voluntarily do this. Quite the contrary, Russia withdrew its signature from the Rome Statute and discontinued cooperation with the ICC even before the full-scale invasion of Ukraine. The ongoing ICC activities are nevertheless important, in my opinion, because the Kremlin's attitude towards the ICC might change in the future. Of course, the Russian political elite wants to be viewed as a monolith, but the recent mutiny of the Wagner Group undermined the public image of Vladimir Putin as a strong leader that can guarantee stability in Russia. I do not have a crystal ball to predict future, but history demonstrates that all empires fall, no ruler is eternal, and who knows, maybe a new Russian government could decide to strike a bargain with the ICC, Ukraine, or Western powers. For example, we surrender the suspects to The Hague, and you lift the sanctions against us.
Thank you so much. I saw that you pointed out the Wagner Group. Maybe the last question could be about it. We've seen that some mercenary companies and other groups not enrolled in the regular army, in the regular Russian army, have been at the forefront of the conflict. For instance, the Wagner Group greatly supported Russia in the conflict, But under international criminal law, can those actors be linked to the public authorities? And can they be considered responsible for an unlawful act under international criminal law?
Yeah, that is a great question. At first, I think we need to clarify the legal status of the Wagner Group. So media, pundits often describe members of the Wagner Group as mercenaries. However, this is not accurate from the legal standpoint, or not entirely accurate from the legal standpoint. A definition of mercenary is provided in international humanitarian law, Article 47 of Additional Protocol 1 to the Geneva Conventions, to which, by the way, both Ukraine and Russia are states parties, sets out strict conditions of a mercenary. In particular, a person shall not be a national of a party to the armed conflict, and a person shall be motivated to take part in hostilities and essentially by the desire for private gain. A somewhat similar, albeit not identical, definition can be found in the Russian Criminal Code. Article 358 of the Russian Criminal Code prohibits mercenarism. In other words, it is very easy for a person to claim that he or she, mainly he, in this context, falls outside the legal definition of a mercenary. Since most members of the Wagner Group fighting in Ukraine seem to be Russian nationals, moreover, Russian convicts, they are legally speaking not mercenaries. This does not necessarily mean that other members of the Wagner Group, especially those fighting in Africa, cannot be called mercenaries. Now, is the Wagner Group then a private military company? Unfortunately, there is no internationally accepted definition of such companies, and the Wagner Group operates in a gray area. One of the few international legal instruments relating to the activities of private military companies in a war zone is the non-binding Montreux document of 2008, which basically reaffirms the existing obligations of states under international law. According to this document, amongst other things, contracting parties, that is, contracting states, that is, states that contract private military companies, have an obligation to enact any legislation necessary to provide effective penal sanctions for persons committing or ordering to be committed grave breaches of the Geneva Conventions and Additional Protocol 1. And these contracting states have an obligation to bring such persons before their own courts. Such persons may also be handed over for trial to an international criminal tribunal. The Montreux document was a joint initiative launched by the Swiss government and the International Committee of the Red Cross. Today, approximately 60, I think a bit fewer than 60 states, including Ukraine, as well as a handful of international organizations, support the Montreux document. Russia has not endorsed it. In 2016, if I'm not mistaken, a legal officer from the Russian Ministry of Foreign Affairs explained that Russia did not participate in the Montreux process because Russia, as that legal officer claimed, rarely uses private military and security companies. The statement does not seem to be sincere, to put it mildly. At the time, Russia was already actively outsourcing active combat to various proxies across the globe, including in Ukraine from 2014 onwards. Surprisingly, there is more legal clarity at the domestic level in Russia. So Article 13 of the Russian Constitution forbids the creation and activities of organizations setting up armed units. So consequently, the Wagner Group cannot be a private military company under Russian law. Rather, it is an illegal entity under Russian law. The Russian authorities discussed a draft law on private military companies for a long time, but these discussions did not even reach the voting stage in the parliament. the Minister of Foreign Affairs, Russian Minister of Foreign Affairs, emphasized that under Russian law, it is not possible to set up a private military company or use one abroad. Interestingly, Vladimir Putin has recently said that the Wagner Group exists, but legally it does not exist. What a paradox. Russia, a state that is obsessed with their appearance of legality, has become a place where legal and factual clarity do not meet. The ambiguity of the relationship between the Wagner Group and the Russian government has given the latter plausible deniability when dispatching the former to serve state economic, political, and military interests abroad. Unlike their present-day private military companies in, say, the USA, the UK, South Africa, or even China, the Wagner Group performs active combat missions, and usually on behalf of the Russian state, while being an illegal entity in this state and operating in an environment of constant denials. The Wagner Group is therefore a sort of novel type of private military and security companies with the features that distinguish it from regular providers of private military force. Ukrainian prosecutors declared some members of the Wagner Group responsible for killing and torturing civilians in the Kyiv province in spring 2022. And there are also allegations of other atrocities committed by these fighters. Here we need to distinguish state responsibility from individual responsibility, as violations of, say, international humanitarian law or the international prohibition of genocide can simultaneously entail both. Vexed legal problems concern state responsibility for the violations of international law. By outsourcing active combat to proxy actors such as the Wagner Group, Russia tries to evade state responsibility. And for this purpose, it not only exploits the loopholes of international law, but also resorts to the blatant denial of facts. According to Article 1 of the Articles on State Responsibility for Internationally Wrongful Acts adopted by the International Law Commission, every internationally wrongful act of a state entails the international responsibility of that state. And this legal document also stipulates that an action or omission must first be attributable to the state under international law, and second, must constitute a breach of an international obligation of that state. The most difficult issue is that of attribution. In principle, the Wagner Group's conduct can be attributed to Russia on three different grounds. First, if the Wagner Group qualifies as a state organ, either de jure or de facto. Second, if it is authorized to perform governmental functions on behalf of Russia as a state. And third, if the Wagner Group's misconduct was performed under the instructions, direction or control of Russia. And according to the recent revelations of Vladimir Putin that surprised many pundits and legal scholars like me, the Wagner Group was entirely funded from the Russian state budget, including the defense ministry budget. Vladimir Putin said that this group received an equivalent of $1 billion between May 2022 and May 2023, only to pay salaries for members of the group. This contradicts the previous consistent policy of constant denials of any connection between the Russian state and the Wagner Group. It also clarifies, fortunately for us as legal scholars, the web of factual relationships between the Wagner Group and the state, and makes it easier to prove attribution, including the complete dependence of the Wagner Group on Russia, and hence consider it as a de facto organ of the Russian state in light of the legal test developed by the International Court of Justice in the Bosnian genocide case. So let's wait and see what else the Kremlin will reveal about the Wagner Group in the coming weeks or months.
Thank you so much. Can I just ask one little question before we end, also because we just have 8 minutes left? Do you think it's possible that they might create in the future a case just similar to the random random trial, or the one that they had for Yugoslavia?
So, as I mentioned, the ICC, the International Criminal Court, is engaged with the situation in Ukraine, and it can in principle deal with 3 categories of offenses: the crime of genocide, war crimes, and crimes against humanity. So there is no need for any other international tribunal, an ad hoc tribunal, to deal with these crimes. And as I said, the crime of aggression is a special thing because of the special jurisdictional mechanism embedded in the Rome Statute of the International Criminal Court, including the Kampala amendments. And there have been many discussions, I touched upon that issue a little bit in my talk today, on the creation of a special ad hoc tribunal to try individuals responsible for the crime of aggression. The likelihood of such a tribunal is unclear at this stage. I would say that much depends on 2 factors. The first is the military component, and that is, to put it bluntly, who wins the war. And secondly, the diplomatic component. Ukraine has been not very active in Africa, in Latin America, in Asia for many years. And now the Ukrainian government is doing its best to establish communication mechanisms with these countries around the globe and to convince the governments of these countries of the right cause, so to say, of the Ukrainian lawfare. And these 2 components, the military and the diplomatic, are closely interrelated. History shows us that states prefer to support winners. So if Ukraine shows that it is winning on the battlefield, or it has the capacity to win on the battlefield, and the victory may have various forms, not necessarily the capitulation of Russia similar to Nazi Germany in World War II. It can be some other forms of Russia's defeat, Russia's loss. But then when states see that Russia is losing, and they would prefer to be on the side of winners, to be on the right side of history, so to say. So, however unfortunate this sort of conclusion may sound, that is perhaps the brutal reality of international relations.
Yes, thank you so much again for your time in the interview. It was really interesting, everything, especially for the topic I'm studying. So I'm going to speak to you now.